For the record, I am the flesh and breathing man.
All right. Well, I'm glad you're breathing. So,
For the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion. I need to know the jurisdiction this court is operating under.
so have a seat. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right. So take a seat.
If I don't come here, warrants will be placed, which I will be kidnapped and held hostage, and I do not want that.
Mr. Casanova, in the human flesh. I'm going to stop you right there. And I want you to hear me clearly.
This courtroom clip opens with something we've all seen before, but rarely handled this well. A self-proclaimed sovereign citizen walks into court convinced that repeating buzzwords like flesh and breathing man, special appearance, and jurisdiction will somehow override centuries of criminal law. On the other side of the bench? Judge Boyd, calm, calculated, and playing an entirely different game. What makes this case fascinating isn't just the arguments being made, it's how they're being dismantled. Instead of yelling, threatening contempt, or escalating the chaos, Judge Boyd chooses patience. And that patience becomes the trap. Because every time this defendant insists he doesn't understand, he's actually digging himself deeper into a legal hole he doesn't even realize exists yet. Stick around, because this isn't just about a courtroom standoff, it's about watching legal reality slowly close in while someone insists they're above it. Pay attention to how kindness, clarity, and procedure end up being far more powerful than force. This one takes twists you won't expect, and the ending says a lot about how courts really deal with these arguments.
Hello, how's it going?
It'll be better.
All right. So my understanding, you want to represent yourself? All right. You're more than welcome to represent yourself, but here's the thing. Everybody says that they can be an attorney because all attorneys do is talk. That's what people think. But they don't realize there's a lot of knowledge, experience, and wisdom behind that.
Absolutely.
So if you want to have a jury trial where you represent yourself, you're more than welcome to do so. But once it's set for trial, it's going to trial, and no one's going to be helping you. The state is not going to say, hey, we see that you really don't know the rules, so let me tell you this rule. They're not going to be doing that. My job is not going to be to help you with objections, help you with motions. That's 100% you. Do you understand?
I do. And are we on the record?
No, we're not on the record. What, you want to put something on the record?
Oh, yes, definitely.
Sure. All right, court is calling 2024 CR 2974, State of Texas Vector versus Hector Casanova. Can I have parties announced for the record for the state? And are you Hector Casanova?
No, for the record, I am the flesh and breathing man. I'm here on a special appearance to clarify any misunderstanding. I am not the legal fiction known as Hector J. Casanova that is on the information there. I just have a few questions to clarify some things.
All right, so if you would like to clarify some things, then the person I need to speak to is the flesh and blood man known as Hector Casanova.
Yes, I am the flesh and blood man, Hector Casanova Jr.
All right, so you are Hector Casanova, correct?
I am Hector Casanova Jr., the flesh and breathing man.
All right, well, I'm glad you're breathing. So what did you want to place on the record?
Well, first, I don't understand the charges that are being brought against me. There are some clarifications I do want to.
All right, so just 1 second, but before we get to that, have you been given a copy of the indictment?
No, I have not.
All right, so we're going to get you a copy of the indictment. Just give me a moment. All right, have a seat. We're going to come back on the record with this.
All right.
So we're back on the record in 2024 CR 2974, State versus Hector Casanova. All right, Mr. Casanova, here's the thing. And I want you to hear me clearly. All right? I am not your attorney. The document that has been given you is a copy of the indictment. I'm not to give you information about your indictment. That's the indictment. That's what we're here for. So any questions that you would have about that indictment, you're going to have to answer those for yourself. Otherwise, the person who will be telling you about what the indictment means and what the numbers are, that will be an attorney. Do you understand?
I do not understand.
This is the cornerstone of nearly every sovereign citizen argument. The idea that there's a separation between a legal fiction and the real, flesh and blood human. The belief is that courts only have authority over a name, not a person. But here's the reality, courts don't recognize that distinction. If you're physically present, identified, and charged, jurisdiction is established. Period. What Judge Boyd does brilliantly here is refuse to argue theory. She doesn't debate philosophy, maritime law myths, or strawman doctrines. Instead, she grounds everything in procedure. Are you the person named? Are you here? Are you charged? That's it. Every attempt by the defendant to reframe reality gets quietly redirected back to facts, and notice something important. By acknowledging his presence without validating his theory, she strips the argument of power. This is how courts neutralize these tactics. No drama. No debate. Just steady movement forward.
What that means is, for example, we can go off the record. I'm giving you a hypothetical. All right. Let's say you needed surgery and you're in the middle of the wilderness. You need surgery and you tell me and you tell the doctor, guess what? I'm performing this surgery on my own. I don't need you. I'm walking out of the hospital. I'm going to go in the desert. Now, maybe the doctor would try to stop you and do other things. But if you go in that desert by yourself, don't tell the doctor where you are. You take a scalpel out in the desert by yourself. You don't get to call the doctor and say, hey, I'm in the middle of the desert performing surgery. I'm going to be my own anesthesiologist. I'm doing all of this. How do you do this? Because they're not going to tell you. It's the same thing here. You're saying that you do not want to be represented by an attorney. You want to represent yourself. So that motion, that indictment, I'm not to tell you anything about what that indictment is. The state is not to tell you, oh, this is what this indictment means. This is the range of punishment. Those are things that you're supposed to do. Do you understand?
I still don't understand.
All right. So just have a seat. This is what's going to end up happening. You're going to have an attorney. That attorney is going to come over to the court right now. You're going to speak to that attorney. After you speak to that attorney, we're going to go forward. Ms. Ferguson, can you call manage to sign counsel and let them know that we need an attorney over here? And that attorney will talk to you. That attorney will tell you what that indictment means. That attorney will tell you the range of punishment. Do you understand?
I still don't understand.
All right. Well, I don't know how I can further make you understand.
Are we on the record?
Yeah. All right. Norma, get someone from manage to sign counsel here, please. All right. Just have a seat and we're going to have an attorney come down. All right.
I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no. Let me just tell you, you'll have my time till 5 o'clock because that's how long we're here. What is going to end up happening is an attorney from manage to sign counsel is going to come down. Do you understand?
I do not understand because I don't feel like I am needing an attorney because I'm here to represent myself as the flesh and breathing man, Hector Casanova Jr. Let's see. All right. So let the record of the court show that I, Hector Casanova
Just one
Jr.
second.
The accused
Just
in
one
the
stop.
Yes, sorry.
All right. We're on the record. So what did you want the record to reflect?
So let the record of the court show that I, Hector Casanova Jr., the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action.
This is one of the most important moments in the entire hearing, and it often gets overlooked. Judge Boyd isn't discouraging him from representing himself, she's warning him. And legally, she has to. Once a defendant insists on going pro se, the court is obligated to step back. No help. No coaching. No second chances. What many sovereign citizens fail to understand is that self-representation isn't empowerment, it's isolation. The rules don't bend just because you don't know them. Deadlines still apply. Objections still require legal grounding. And ignorance is never a defense. Judge Boyd makes this crystal clear. Once this train leaves the station, it's not stopping for confusion. And the defendant saying, I understand, here becomes critical, because later, when he claims he doesn't, the record will say otherwise. This isn't kindness, it's legal insulation.
Furthermore,
let me
let the
stop
record
you.
also show.
Casanova, let me ask you a question. Have you been given a copy of the indictment?
I believe so, yeah.
All right, so let the record reflect that Mr. Casanova has been given the copy of the indictment. And the copy of the indictment, it tells him what he is charged with. You may continue.
Now, these charges, are they, civil? Is this a civil charge or a criminal charge?
All right, that is something that if you had an attorney to represent you, they would be able to tell you. What the court can tell you is that you are in a felony court and this is a criminal court.
Okay. So, this being a criminal, let the record of the court show that the action against me is criminal action. My following question would be, the Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under the admiralty or military tribunal. In which of these two jurisdictions does this court intend to try me?
All right, so this is what is going to happen, Mr. Casanova. Someone from managed assigned counsel is going to come over and you can speak with them or not speak with them. But the questions that you are asking the court are not, some of them are not in any shape, form, or fashion related to the fact that you're in a criminal district court. Do you understand?
I do not understand.
Okay.
But I don't think you'll be violating your oath of office if you did your duty under the Constitution. I am not seeking legal advice. What I want to know is legal intent.
Mhm.
I have the right to appear as myself in my own person without a licensed attorney. In order to intelligently defend myself, I need to know the jurisdiction this court is operating under.
Mhm.
Let's see. So therefore, will you please answer the question so that way this court is properly identified?
All right, you're in the 187 District Court. It's a criminal court. You're on the 4th floor.
Thank you. This Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under
All right, I'm going
admiralty or
to
military
counsel.
tribunal.
I'm sorry, Mr. Casanova, in the human flesh. I'm going to stop you right there. What is going to end up happening, I want you to hear me clearly. An attorney is coming over for managed assigned counsel, period. That's it. So have a seat. Managed assigned counsel will come over. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right. So take a seat.
Yes, ma'am.
Thank you.
Here's where the strategy starts to backfire on the defendant. Repeatedly claiming you don't understand isn't clever, it's dangerous. Courts aren't required to tolerate willful confusion, and at some point, it triggers a different legal pathway altogether. Competency. Judge Boyd's response here is subtle but powerful. She doesn't accuse him of playing games, but she documents the possibility. And once competency is on the table, control leaves the defendant's hands entirely. Evaluations, delays, and forced counsel can follow. This is the paradox of sovereign tactics. They rely on refusing to engage, but the justice system interprets that refusal as either obstruction or incapacity. Neither outcome favors the defendant. And every time he doubles down, the court tightens its grip without raising its voice.
Mhm.
I've informed him that I'm here, to help him in whatever he needs help with.
Mhm.
He's gonna consider what help he thinks he might need from me, and I know he wants to put something on the record.
Okay. All right. And so you'll be appointed as standby
Yes.
counsel then?
I've kind of explained my role and what that means and how I can help him with something as simple as e-filing or that type of thing. So
All right. We're going to go back on the record in 2024 CR 2974, State versus Hector Casanova. Mr. Casanova, if you'll come forward. Yes. All right. So, Mr. Casanova, Mr. Bonk is going to be your standby counsel. And that's someone that if you have questions, you can ask him legal questions or what you may have.
Thank you for your consideration.
All right.
Uh,
And he informed me you wanted to place something on the record?
Yes, for the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion.
All right. Who threatened or coerced you to come to court?
The county of Texas.
How so?
Well, if I don't come here, then warrants will be placed, which I will be kidnapped and held hostage, and I do not want that. So that's why I'm here under special appearance to clarify any misunderstandings and to let it be known where I stand on the record.
Okay. Is there anything else?
I said everything that needed to be said.
Okay. All right. So what we're going to do is we're going to recall your case in 1 month. It's going to be a discovery setting. So that's to make sure that you have all the information that the state has concerning your case. Do you understand?
I do understand.
All right, Ms. Ferguson, if I can have a 30-day reset for Mr. Casanova. And after you receive all the discovery, then the next setting is going to be a plea deadline date. The state will tender an offer to you at the next setting. And then I'll give you your plea deadline date, and you can accept the state's offer or come to an agreement or not. If you're unable to come to an agreement at that time, it'll be scheduled for jury trial.
Thank you, Ms. Boyd.
You're welcome. Any other questions?
I have no further questions.
All right, so Ms. Ferguson is going to give me a date, and then you'll sign it. Mr. Bonk will sign it to signify when you're to come back. All right.
I appreciate your time.
All right, you're welcome, and thank you for dressing appropriately for court. What date, Ms. Ferguson? All right, so we'll be back on July 29th. All right, once you sign the reset form, you'll be excused. Yes.
If something were to come up and I need to maybe reschedule that date, is that a possible thing to
You'll
come
need-
up ahead of time?
You'll need to speak to the court coordinator, and they will let you know. I will tell you the rescheduling of cases. Are you in the hospital? You're not in the hospital, you need to be here.
Okay,
You understand?
so pretty much no excuse, be here.
Yes. All right, thank you.
Thank you.
This is a textbook example of constitutional cherry picking. Yes, the Sixth Amendment guarantees the right to know the nature and cause of the accusation, but that right is fulfilled by the indictment, which he has. And the judge confirms it. On the record, what the defendant is attempting here is reframing a procedural safeguard into a performative accusation, hoping the words themselves create leverage. But constitutional rights don't operate on vibes, they operate on documentation. Judge Boyd shuts this down without theatrics. She doesn't argue constitutional theory, she references process. And that distinction matters. Courts don't debate amendments in real time, they apply them. And once the record reflects that the indictment was provided, this argument collapses entirely. Clip 5. This is where sovereign citizen law really shows its cracks. Admiralty law, military tribunals, gold fringe flags, none of it applies here. Criminal district courts operate under statutory and constitutional authority, not nautical fantasy. Judge Boyd doesn't waste time correcting legal mythology. She simply states the court's identity, jurisdiction, and authority. That's all that's required. Courts don't need to justify their existence to defendants, and notice how the defendant keeps asking questions framed as traps, but none of them land. Because jurisdiction isn't a riddle to solve, it's a fact to accept. Every time he refuses to accept it, the court moves forward anyway.